Can a man be raped in Nigeria? This is one of the questions that you ask when you examine the provisions of the law relating to the offense of rape in Nigeria. And for the purpose of this lecture session, I would properly explain the position of the law in Nigeria in relation to whether or not a man can be raped. Firstly, before you can understand anything in criminal law, you must do that in light of the express statutory provisions relating to that particular subject matter. So therefore, when we want to consider this issue, it is of fundamental importance that we do that in light of the principal legislations governing the offences of rape in Nigeria. As expressly provided for in the provisions of Section 357 of the Nigerian Criminal Code and Section 282 of the Penal Code, a rape is actually a sexual offense that is committed against the person of another. But a close examination of these provisions will reveal to us that the Criminal Code and the Penal Code restrict the offense of rape to something that can only be committed against a female person. Because when you examine the express wordings of that particular code, the wordings itself reveal to us the intention of the legislature that rape is not to be committed against a male person. So, apart from the fact that the essential elements for the offense of rape according to the different codes is the penetration, the absence of consent, the provisions of the criminal and penal code made it clear that a rape is only one that can be committed against the person of a female. This is seen in the express wordings, he or she. The provisions of the criminal code says that when an unlawful intercourse is committed against a female person, even the provisions of the penal code says that a man commits the offense of rape when he does some certain things with the absence of the consent of the victim. After a proper examination of the provisions of these two different codes, we would come to an understanding that the offense of rape can only be committed against a female person. So therefore, the offense of rape cannot be said to have been committed against a male person. However, some certain deviations have been made upon a close examination of the recently enacted statute, the Violence Against Persons Prohibition Act 2015. It provides that the offense of rape is not just something that is committed against a female person, because from the express provision of Section 1 of the VAPP Act, it says with the use of the word he or she, they can infer that the intention of the legislature enacting that particular statute wants the offense of rape, which was initially restricted to one that can be committed against female persons, to one that can both be committed against a male and a female person, such that the express wordings with respect to the provisions of the criminal and penal code restricting the genders that can only become a victim of rape has been widened in the Violence Against Persons Prohibition Act, when we can see that the use of the words he or she qualifies the statement that a man under the provisions of the Violence Against Persons Prohibition Act can be raped. So, according to the previous position, the requirement for someone to be held criminally responsible for the offense of rape to be proven is actually an absence of consent, a penetration, and a female person. But under the Violence Against Persons Prohibition Act 2015, this restrictive scope has been widened such that the requisite element that must be proven before the offense of rape can be established is a penetration, not just on the vagina as required under the criminal and penal codes, but a penetration on any opening in the body. Not just a penetration on any opening in the body, a penetration that is done by any material Not just that, the provisions of the Violence Against Persons Prohibition Act says that the offence of rape from that particular section is purported to be one that can be committed against a male and female person. However, when you examine the provisions of Section 47 of the Violence Against Persons Prohibition Act, you will discover that that particular law, that particular statute applies only in the Federal Capital Territory, Abuja. That means that other states can only incorporate this particular provision in their law when they have domesticated that particular act. So while we know that the general position of the law in relation to the offence of rape is that it cannot be committed against a man, we must appreciate these modifications that have been given by the enactment of the Violence Against Persons Prohibitions Act. This is the well-settled position of the law, free from contradictions. Do well to follow us so as to stay updated and also so you can keep learning the law daily.